I'm really pleased now to welcome our first two panelists, and they are Kara Dansky and Lierre Keith. Kara Dansky is the president of Women's Declaration International USA. She's the author of The Abolition of Sex, which was published last year, 2021, and is widely available and fantastic. She is also a lawyer or attorney, as I think Americans might call it. We also have Lierre Keith, who is the chair of WOLF, Women's Liberation Front, also from the USA. She is a prolific author of many good books. The most recent one she's co-author of is Bright Green Lies, which is excellent. So I've read both of these books and they're both highly recommended. Thank you so much, both of you, and over to you.
We had a huge win in the United States, and this is basically the first, the best. We're all stunned because this has gone so well. And this was a free speech case. Green is a man who thinks he's a woman, and he sued the Miss USA beauty contest because he wanted to be a contestant, and the women told him no. So he took them to court. And you may wonder, well, what is a feminist group doing supporting a beauty pageant? And you know, the real issue is not that it's a beauty pageant. The real issue is that women should be able to say no to men. So this was a First Amendment case. Again, it's, you know, this guy wanted to join this beauty pageant, and he originally won. It was a state anti-discrimination law, and the women just kept saying, no, you can't be in our beauty pageant. So it, you know, it gets bumped up to the next higher court. But the reason that we took this on, there were two big reasons. The first is that almost all of these First Amendment rights cases that have come sort of across our desk at this point, they're religious. They're brought by religious people. And their argument is, hey, the Bible says it's male and female. It's against my religion to call a woman, you know, with a male name or using a male pronoun, and we're supposed to have freedom of religion. Now, freedom of religion is under the First Amendment, but we feel like that's an incredibly weak argument, and it only works for people who are very religious. To us, it has nothing to do with religion. It has to do with reality. So to date, it's been really hard. We have submitted radical feminist arguments to the courts in these cases and hope that they make more sense than the religious argument. But this was not a religious group. This was just a group of women who didn't want a man. And we thought it was just, this was going to be, you know, it's well worth our time to jump in on this one because it was not a religious case. And then the other thing is that it was actually a women's group, because these other cases are usually somebody's suing a school because the college or the local school is making a teacher use pronouns. So the school is what's being sued, but this was a group of women being sued. So on both cases, we felt like, you know, this was a brief that we really wanted to submit. And we won. The opinion that the judge ruled with this, they actually quoted our brief. Now, when I say our brief, I want to be clear. I'm not a lawyer. I did not write this brief. This is not a skill set I present. But we have this incredible lawyer, Lauren Bone, and honestly, this is her win, and she should be doing this presentation. She didn't want to. She wanted me to do it. So, but we need to throw the glory on Lauren, because she's the one who wrote this incredible brief. And I highly recommend that all of you, if you get a moment, go to the Wolf website and read the document that she wrote, because it is just a radical feminist argument, just swords and knives and shields just going full force with the rad femery. It was just an amazing thing that she did. So, okay, this was one of our arguments, that women need free speech and the right to associate together in order to protect and advance our rights. This seems obvious, but we're having to, you know, we're having to argue this in court now. And what he said was that laws that protect historically marginalized groups should apply to me, the man, and not to women. So what his lawyers tried to do was position him as the poor oppressed person and women as this larger, terrible category that oppresses people. It's obviously completely backwards. Our next argument, we said Green is a man and the law protects sex. It does not protect his gender feelings. And he is a man. And he said, I'm biologically female because I am stereotypically feminine. That's literally what this guy argued. He said, because he is so lovely feminine, whatever, with his curly and his makeup, and that makes him a woman. That was literally what he tried to argue in court. He said that he was indistinguishable from, quote, cisgender women, and that he is a natural born woman. Those were his words. He is a natural born woman. Now I got to tell you, infants know the difference between a male and a female face. Infants, like people who are 3 weeks old, who can see enough. The first thing they can see is the difference between a male and a female face. My dogs know the difference between men and women. There's not a culture that's ever existed that does not know the difference between men and women. But he is claiming he's a natural born woman because he likes putting on makeup. Okay, our argument was that gender identity ideology is regressive and harmful to women. And the court agreed. This is why this is a victory. And he said, I'm a biological female because I'm stereotypically feminine. So we were quoted. This beautiful brief that Lauren wrote was actually quoted in the opinion, which this is like this minor miracle that fell upon us. So Green believes that femaleness is defined by femininity, which is a socially constructed role that by design keeps women in a subordinate, subservient position. That is what Green believes about women's natural state. Feminists have been fighting against this toxic system for generations. So that's what Lauren wrote in our brief, and that's what the judge in part quoted. So this is the beginning of the section where Lauren explains the radical feminist arguments against gender identity. To believe that sex is determined by a gendered soul or a feminine appearance rather than biology is to believe that femininity is the same thing as being female. That's offensive and harmful to women, and it's also antithetical to civil rights, but the court is being asked to adopt a very regressive belief. And again, this is more of this wonderful brief that Lauren wrote. A gender identity is a subjective statement of self-perception. And so under that, a woman would simply be a person who identified as a woman. But what would that actually mean? So it completely destroys, just the actual reality of what sex is, which she says is nonsense. And so he believed, the judge completely agreed with us that, and the ultimate point is that there were lots of reasons to object for this man being allowed into this beauty pageant. And all of them fall under the First Amendment, and women have First Amendment rights. So it was kind of an amazing thing. And then I'm also supposed to point out to you all the people who were on the other side of this. So for instance, the Lambda Legal Defense Fund, the National Center for Lesbian Rights, of course, people like, the ACLU. And a lot of their arguments are that women are now the big oppressors and this poor man is the oppressed person. They tried to use this case, that's the Roberts case. And that case was, so there was a men's group. Women were already members, but they weren't voting members. And the women they sued to try to get voting rights in this group as well. And the men claimed that they had, quote, freedom of expressive association. Now that's one of the things that the women in the beauty pageant claimed. These men lost though. So this man, Green, what he's trying to say is that this is parallel, that because the men weren't allowed to have that, the women shouldn't be allowed to have it, and therefore he should be allowed to join. But we say there's a significant difference because, first of all, there's the power differential. Like, women don't have a chokehold on power like men do. And second of all, that, it's not parallel because he's not an oppressed person. So it just shouldn't, this is just not the same thing at all. And the court agreed with us. So that's really the important thing. Anyway, so it's a unique evil. I think that was the point where we were all just laughing ourselves sick, but that is what this guy ruled. So we've had a bunch of cases this year that have been pretty good. This is absolutely the best one. And the reason that we're going after a lot of these First Amendment cases is I really want people to understand we are this tiny little David against this enormous Goliath. And these other groups like the ACLU and even Lambda Legal, I mean, they have stables of lawyers and we have one. So we're trying to figure out, like, what is the best use of her time and then the tiny bit of money that we've been able to collect from radical feminists to try to do our lawfare. And these First Amendment cases keep coming up. So it seems important to keep engaging with them. And now we actually are making progress. So it seems to have been the correct strategy. So the Merriweather case, that one was won by Mr. Merriweather. He is a teacher. It was one of those teacher religious cases, but he is not being forced to use the pronouns. And we did submit a brief in that case, also very radical feminist. This one is ours, though. Green is just absolutely amazing because radical feminism was quoted. This one's coming up, Blaming, that's also about the forced pronouns. And then Greenberg, this one's terrifying in the United States. A lot of people haven't heard about this because it only affects lawyers. But what's happening is they're trying to change the ethical rules for lawyers such that lawyers will be forced to use the pronouns. Lawyers will be forced to use ridiculous language like calling men women. And this really should just strike terror in people's hearts. So we did submit a brief for that one as well. And, who knows where that one's going to go, but that just can't be allowed to stand. So that was our great big victory. And again, I just want everybody to read the brief if you get a moment, because it's just the clearest radical feminist argument you could ever want. She just absolutely killed it. And support Wolf if you can, if you live in the United States especially. And I'm going to turn this over to Kara, who is an actual lawyer and probably has more intelligent things to say than me.
I've thought for some time now that when we're going to win, and we are, it will be because men in Black robes like the First Amendment, and that's proving to be true with what Lierre is saying about speech. Okay, so as Lierre said, this is not about beauty pageants. Most of us are categorically opposed to beauty pageants. In 1968, feminists protested Miss America, and had I been alive then, I would happily have joined them. So this is just a very fun poster from that era. This is literally a hard copy of a flyer inviting women only to travel from New York City to Atlantic City for that very purpose. And I just want to thank Bonnie Atwood, who may be here today, who dug out this actual flyer from her files for us to hand out at the WDI USA convention in September. So thanks to Bonnie. So celebrating this ruling is not about celebrating beauty pageants. It is instead about celebrating women-only spaces and freedom of speech. Now, when I first heard about the ruling, I was excited to hear that it was a victory for free speech for women. But when I finally sat down and read the entire ruling, I was thrilled to see that it is really so much more. So I want to just read the gist of the ruling, in part because it makes it so clear just how crystal clear this ruling is, but also because of the language that the court uses. And I'm going to use quotes where the court uses quotes because I think it matters. Okay, so this is directly from the ruling. Anita Green, who self-identifies as an openly transgender female, sued the Miss USA pageant, alleging that the pageant's natural-born female eligibility requirement violates the State Public Accommodations Act that Lierre mentioned. Okay, the district court, that's the lower court, granted the pageant's motion for summary judgment, holding that the First Amendment protects the pageant's expressive association rights to exclude a person who would impact the group's ability to express its views. We conclude that the district court was correct to grant the pageant's motion, but reached this conclusion not under the First Amendment's protection of freedom of association, but rather under the First Amendment's protection against compelled speech. So it's very interesting that the court uses the phrase self-identifies. This appears to me to be an implicit acknowledgement that trans is just an identity and that it isn't real in any material sense. Now, the court isn't saying this explicitly, but I'm having trouble imagining a scenario in which the court could manage to disagree with that assertion, given its deliberate choice to use the phrase. Judges, particularly federal appellate judges, choose their words carefully. I've read other judicial opinions that say things like, plaintiff is a transgender woman. The phrase self-identifies here reads very differently. What's even more interesting for those of us immersed in the gender wars is this, and again, I'm quoting the court. As explained in the briefing, Plaintiff Green claims to have been assigned the gender of male at birth, but came out as transgender at the age of 17. Further, Green later took medication to alter hormone levels and underwent cosmetic surgery in which Green's male anatomy was reconstructed to appear as female anatomy. Now, those of us in the trenches of this debate know that some people claim to be trans because they have taken hormones and had surgeries to make them look more like the opposite sex, whereas for others, trans is just an identity that you can just declare, a bit like Eddie Izzard claiming to have a girl mode and a boy mode. What the court seems to be saying here is that Green self-identifies as transgender even having had the hormones and surgeries, which to me strongly suggests that this court thinks that even when a person has had the hormones and surgeries, trans is still nothing other than a self-identification. I would go further and call trans an outright lie, but this concession from the court is pretty astonishing, and I'll take it. The phrase claims to have been assigned the gender of male at birth is another signal to me that this particular panel of the Ninth Circuit is not caving to the nonsensical idea that sex is assigned at birth. Finally, the fact that the court uses the phrase cosmetic surgery to describe a trans surgery, or to use the preferred contemporary euphemism, gender affirming care, is even more astonishing. We have been referring to it as cosmetic surgery for years, and this is the first time I have seen that characterization appear in a court ruling. I want to say a few things about what might happen next, because someone in the chat asked the question, will it be appealed? As far as I can tell, the plaintiff, Green, the man, has three options before him. He can, one, do nothing. If he does nothing, this ruling will stand throughout the Ninth Circuit, which is a big deal. We have other cases pending before the Ninth Circuit, and this opinion is controlling in the Ninth Circuit, which includes the states of California, Oregon, Washington, Arizona, I think Nevada, and I think Montana and Idaho. So if this ruling stands, that will be massive. There are some people who think that it is in the plaintiff's strategic interest to do exactly that because this opinion is so strong. I don't know whether he will do that. I don't know whether he will let this stand. It strikes me as highly unlikely that he will just let this stand, but he might. A second thing he can do is petition to go before the full court. The panel that made this ruling was 3 judges, and the ruling was a majority of 2 and 1 judge dissented. The Ninth Circuit consists of 29 sitting judges, and Green has the right to petition to go before that full court. He can do that if he wants to. And it's anyone's guess as to how the full court would rule if he chose to do that. The other thing he could do is petition to go before the Supreme Court and bypass the full Ninth Circuit completely. Now, none of us know what they'll decide to do. Clearly, our opposition, as Lierre said, is very well funded. So any of those are on the table. And WDI USA has been talking internally about getting involved in this litigation. We did not get involved at the lower court stages because we knew about Wolf's brief and we totally support it. So we chose not to get involved until now. But if this case proceeds, we think we're going to have to find a way to get involved, and we're very excited to do that. So those are some options before the plaintiff, and we'll wait to see what happens, and we'll keep you all informed. Just before I say goodbye to you all, I want to also briefly mention, coming on the heels of this astonishing Ninth Circuit victory, we literally just heard yesterday about a case coming out of the state of Vermont, where a young woman, athlete, was in her locker room and a male student entered the locker room, and she didn't like that, and she complained, and she said some things about her opposition to the man being in the girls' locker room. Her father was a coach at the same school, and he also made some public statements opposing allowing men or boys into the girls' locker room. The school, in turn, punished both of them. They informed the girl, the female athlete, that she was going to have to attend a restorative circle and hear all about how her opposition to men in the changing room, was offensive to a marginalized community. And she was going to have to write an essay to school administrators, setting out how she intended to reform herself. And if the essay passed the school administrators' requirements and if it met their expectations, then she would be rehabilitated. The father was threatened with termination from his job as a coach. They sued under the First Amendment, and we just learned yesterday that the school has completely backed down. The school has removed any sign of punishment or recrimination against the girl or her father. And we think that this is a sign that everyone knows what's happening here. Everyone knows the girls are not going to stand for this. Parents are not going to stand for this. And we think our opponents are on the run, and we're very happy about it. So thanks to WDI for having me. Thanks to Lierre for talking about this great case. And thanks again to Wolf for the wonderful brief.